All right, you're looking at a live picture there of James Ray, the man, 3 counts of manslaughter and the deaths of 3 people who died after a Sweatlodge ceremony at one of his retreats back in 2009. Melinda Martin has been on the stand here. She actually worked for James Ray's company. She's the first witness on the stand in this 14 days of testimony that we've heard now, who was not inside that Sweatlodge ceremony when everything basically went into chaos and 3 people ended up dying. I want to bring in Keith Murray right now and talk to him about what he sees so far with this. Keith, good to have you with us. I know we've been all over Casey Anthony today as well. Now we've moved to James Ray. Based on the testimony you've seen in this case so far, today, I should say, what do you think the prosecution is trying to get out of Melinda Martin?
Well, so far what we're hearing is, what I can gather more from the defense from hearing what's gone on so far, and it sounds like their catchphrase is going to be, what did James Arthur Ray know? What was he aware of while all this stuff was going on? And I think what they're doing is they're going early on in the process to show there's a little bit of chaos here. His handlers were handling it behind the scenes, such as with these 2 sisters, who the one was trying to get the other out and was not being given access to her own sister. Mm-hmm. So I think they're going to try to set the stage that maybe some of these handlers were more involved than Mr. Ray himself was. But that's the defense aspect of it. Now,
we remember that he's charged with 3 counts of manslaughter. The jury here has an option, as I understand it, to convict on a lesser charge of negligence. What you know of this case thus far, has the prosecution been able to prove manslaughter to this point?
Well, the interesting thing about manslaughter, and I actually went through and parsed out the Arizona statutes, is it's recklessly causing the death of another person. But they have to show that a defendant was aware and consciously disregarded a substantial and unjustifiable risk that constituted a gross deviation of the standard of conduct that a reasonable person would observe in the situation. So they had to show that he knew that this situation could get out of hand as it did. And another interesting aspect of it is that voluntary intoxication is not excusing. So even if he was under the effects of the Sweatlodge and he was not in his right frame of mind while it was going on because of participating in it with them, mm-hmm. It's not excusing to him.
Because at the end of the day, he was still in charge of all those people. But what about the fact that all of those people that were in that Sweatlodge signed waivers? That's a big part of the defense, saying, hey, look, they went there under free will.
It is a big part of the defense. They went there in their free will, but what they're going to try to show is that there was this cult mentality surrounding this guy. And, they engaged in behaviors like, treating people with a code of silence, putting people out in the woods for 36 hours alone in a 6-foot circle without food or water or any kind of, sanitary facilities. You can hear that they're controlling the participants in terms of trying to keep them in certain rooms, and like with the sister, I think is one of the things they're trying to show, is they would not allow her access to her own sister to get her out of there. Mm-hmm. So I think they're trying to show this cult mentality. I think another issue going towards the cult mentality is these recapitulations where they're getting them to reveal intimate personal details such as this talk about their sex lives to him. In a way to build up trust in him so that he can further control them and guide them through this journey he's supposed to be taking them on.
All righty. Again, you're looking at live pictures. Keith, thank you so much. Keith sticking with us here. You're looking at live pictures there to your right of James Ray in court. The attorneys are in the middle of a sidebar with the judge. We're going to take a quick break. We'll take you back to court live on the other side of it. Stay close.
We're live in Orlando, Florida today for a critical 3-day hearing before Casey Anthony's murder trial. Prosecutors want to use scientific evidence in their fight to convict Casey of first-degree murder. They say a lab found evidence of chloroform and decomposition in the trunk of Casey's car, but the defense says the science is not reliable. Now, criminal defense attorney, former FBI intelligence expert Keith Murray is with us. Keith, great to see you. Let's talk about what's happening in the courtroom right now, which is the canine evidence. And these are trained cadaver dogs that are used oftentimes to find remains, to find bodies, to locate people who have died. In this case, they've got a hit on the trunk. They've got some hits in the backyard. Is this stuff reliable?
That's the question that's, the defense is trying to get at here, and they're saying it's not reliable, it's inadmissible, and it's basically incompetent. I mean, not to be flip, but you can't put the dog on the stand.
Right.
And have the dog testify. So you have to have the dog trainer, the dog handler come in and say the dog alerted in the way he was trained to alert. The problem with the state trying to put this evidence in is that apparently there was no biological material discovered at any of the locations that the dogs alerted on in the yard, and what was found in the trunk is somewhat questionable.
So, and here's the question. Are they trying to keep this out because of the way it was done in this particular case, the results in this particular case, and this particular dog? Or do you think they're making a general argument that, no, you can't have this type of evidence in a...
The catchphrase is that its probative value outweighs its prejudicial effect. And what they're going to... they put on a big dog and pony show, so to speak, having the dogs go out there, but the dogs didn't find anything. So in putting on evidence that you put the dogs out there at all, how is that going to influence the jury? The dogs found... alerted on spots. Nothing was found in those spots, so it seems to be much ado about nothing that they're trying to put the dogs in there at all.
Well, yeah, but when it comes to the trunk, though, it becomes huge, because this is the basis of the prosecution case. They're trying to get in a bunch of evidence. You've got the hair that we'll talk about in a moment. You've got the dogs hitting on the trunk. You've got people saying it smelled like there was a dead body in the back of that trunk. And then you've got another issue that's going to come up in the next couple of days. You've got the lab up in Tennessee where they took pieces of the lining of the trunk, put it inside a tin can, sealed it, and then tested the air inside those cans and said the air had chemicals that are consistent with human decomposition. So the prosecution, this is another piece to add to all the evidence related to this trunk where there was no body found. But it's Casey Anthony's car.
I think the single biggest problem they're going to have with that is the fact that this car was impounded. It was sitting in a lot in the sun in Florida in the summer, and there was trash and bags of food in there. And this chloroform at Oak Ridge National Labs, it's an experimental test, and it will test positive for chloroform that's in there. For example, if the drinking water down in Florida is chlorinated, it would test positive if somehow drinking water got in the trunk of the car. It would test positive if, hypothetically, towels from somebody using a swimming pool, chlorinated swimming pool water, would show positive tests for chloroform. And then you've got the decomposing food. This test can't discriminate between decomposing animal remains and decomposing human remains giving off chloroform. It also false positives on meat that you might buy at the supermarket that decays, and it also tests false positive for degreasers and cleaning agents. So there's a lot of wiggle room in the defense to attack this on the stand should it get that far.
Keith, as I look at this case, and the scientific stuff important, but let's say that the scientific stuff is either excluded or at trial is so far diminished by cross-examination and other experts who come in that the jury doesn't really rely on it. Does that open the door for a not guilty here? Is that the road to not guilty? Because we know we still have that one big piece of evidence that most people begin and end with in this case is a mom has a 2-year-old daughter. Her daughter's missing. She doesn't tell anybody.
Right. I think, for lack of a better word, her squirrely behavior during that month, it certainly is going to be held against her. Lacking any actual physical evidence connecting to the crime, I've said this before, you put 12 people in a room with all that evidence, you never know what they're going to do. It's possible they could look at a lack of scientific evidence, but look at her behavior and still find her guilty. They may let her off. I don't know if there's a lesser included. And again, this is a death penalty case. It's an extremely high standard. The stakes are very high, and they may feel if the forensics aren't up to the challenge, they may have to let her go.